actually, 13's always been lucky for me too.
Just wondering what you're talking about. Thought you sounded like sports numbers or something.
We are finishing section 4, and going to get to section 5 today as well, so that we can do section 6 on Thursday, because we have lost a fair amount of time to the snow. So that we've got a number of things that we have to talk about and be able to move through with some level of speed. There were a number of articles in that section 4 that I think you should at least think about and try to figure out how it all factors into your role as a professional and your obligation to act with professionalism. For those of you, well, all of you who are now graduating and will pass the bar after 2014, you are also required by the Supreme Court now to take a course sometime within the first 12 months of your passing the bar, not before law school, but after law school, on ethics and professionalism from the standpoint of the practicing bar, trying to provide you some additional information. Because obviously there's a lot of areas here where you can get into trouble. And a lot of it really sort of deals with you having to need to figure out as the young advocate what you can and can't do and what you should and shouldn't do, because I think it's there are many areas where you fall into some of these traps, and sometimes you're in over your head before you realize it. And I think there's some basic things that you need to start to think about in law school to get yourself a little more squared away. Let me ask you, though, about the couple of the articles before we do the first technology safety systems versus DEPINET case. And the articles are a little older, are older at this point, but to some extent, to a large extent, the practice of law you guys enter into requires a reasonable level of sophistication with respect to technology. Whether you're comfortable with it or not, now you need to be able to acquire those skills over the time period you have left here, because you are able through technology to be able to handle larger cases, compete with other law firms, much larger law firms, and be able to assist your clients. Are there skills that you think you should have that you don't have? And if there are, what's your plan for acquiring them over the course of the next 12 or 18 months? Because, see, one thing I always think about in this regard is it gives you a huge leg up with respect to entry into the profession and the ability to obtain a job, because there's a lot of older lawyers who aren't necessarily interested in the technology, or even if they are, aren't interested in spending the time to acquire that knowledge. So if I bring someone in who has both technological skills and professional skills, understands how to try a case, how to draft agreements and do things like that, and can understand how the technology aspect works, either with respect to litigation or just simply law office management, then that's a real plus. So are there skills that you wish you did have? Are there skills that you have you think that will be more advantageous? And if you don't have the skills, what's the plan for the next 12 months to get them? Go ahead.
I've talked to lawyers that have said that Westlaw in school is like crack because it's free, and then when you get out, you can't afford it.
I don't disagree with that to some extent.
So like, how are you, like, you learn how to use this technology here, then when you go out, it's not available all of a sudden.
It is available, and there are packages that are going to cost actually probably twice as much as your cell phone on a monthly basis. You can get packages for Westlaw for, say, Massachusetts related materials for as low as a couple $100 a month. And that's probably about as low as you're going to get. The problem is that at a lot of law firms, when you're going in then and you want to do research, if they don't have a monthly usage plan, you're paying per use. And they don't want you sitting there fooling around like you did in law school, hunting and pecking for a couple days at a time to find the case. They can't afford that, so it's got to be done quickly and profitably. And so part of what you should be doing here is, and we should be helping you do that, is to really fine-tune some of those skills, because you should understand that in the real world, even if you have unlimited usage, we don't want you sitting there for 10 hours to find the case you need. The faster you find it, the faster you bring it, the faster we can move on, because I can't charge for 10 or 12 hours worth of time on a single case that you should have found much faster than that. But the bigger problem, as Jim points out, is that if you're not acquiring any knowledge of the books, a lot of the law firms will still have Massachusetts statutes or the federal statutes and the like, and they will expect you to be able to find the pertinent material within there. And so you shouldn't just rest on one set of research skills. You need both. And then you really need to start to think about, well, what am I going to do when I get out? Because this unlimited access to Westlaw, unless you're prepared to pay for it, is not going to be there. But at the other end of it, there are plans, which I don't know what you guys are paying for cell phones these days, but it's probably not going to be significantly more than twice that bill where you'll be able to access Westlaw. And at the end of the day, it's a cost of doing business. You're going to need to be able to do legal research. There's a social law library in Boston that provides access. A lot of the state libraries provide access to the materials. You at some point have to figure out how to do it cost effectively. There's no ifs, ands, or buts about it.
Doesn't every courthouse, I mean, you can go in pretty much any courthouse and use the law library?
You can, but they're not likely to allow you to use unlimited electronic access either. We're talking the books. And I don't see a lot of you hanging around in the stacks anymore.
Yeah. No, I mean, Westlaw, I mean, they have it, well, I know they have it like in Salem, and like
But they're not going to let you sit there for 12 hours at a time doing your Westlaw research like you could downstairs.
Right.
And that's the problem, is that you get used to something that is relatively easy and requires a modest amount of effort on your part. That's just not the way it works in practice. We can't do that. We can't do that from a number of different standpoints.
I figured everybody must just pay for it. I mean, how could you go without that nowadays? You know what I mean?
Well, it depends on the size of the firm, and it depends on what package they have. When you say everyone pays for it, okay, so we pay for a mass package. Does that provide us access to the federal database as well? Probably for an additional fee it does. So then I just get mass and mass feds, or do I get New York? Do I get California? The problem is that why do you go on what you want to be able to have access to, and then forms and the other things that you, as a law and MCLE, the things as a practitioner you would want to access, the fee is going to increase for you. And the problem with is the more you add to that monthly expense, it means the more money you have to bring in order to make that practice profitable. But at the end of the day, your point about, well, you got to be able to do legal research somehow is true. The question now is trying to figure out how to do it cost effectively. Google probably will only get you so far without calling on your malpractice before too long. What else? So research skills. What other skills? You gave me that face over there. What's that about?
I always look like this.
I know, but what is the look was like, I don't know where to begin.
Pretty much. I don't know, just, I think for me, I want to get an internship where I can work with a litigator and learn practical trial skills.
And I understand that, but you know, one of the things I think about now, if I had a litigation firm and I was bringing someone in, I'd want someone with a fair amount of technological skills who could assist me to a much greater extent doing e-discovery. And I'll tell you why, because otherwise I've got to farm it out, and the companies that I'm going to bring in to assist with e-discovery are going to charge up the kazoo. So to some extent, if someone has those skills, makes a lot more sense to bring in, and some litigation skills, has both, then that's a no-brainer almost. And that's what I'm trying to sell you a little bit on, is you're in law school, to try and see what you can do about acquiring those skills now, as well as you start to think about it, because it's a twofer then when someone says, I've got a job opening, what can you do for me? The more skills you have, the more you can do, the more it makes my decision much easier about bringing you in. I can find someone to try a case. Can I find someone to try a case and can understand the technological aspects of where we should be looking for information, how we should be varying the search terms so that we'll pick up even misspellings and the like. I need someone. At the end of the day, I just signed into this case. It's a huge case, but virtually everything is in the electronic vault. And I still like to turn the page every now and then and look at paper, especially when I'm doing discovery. But the fact is that all of this stuff, and there potentially are millions of documents in the vault. The only way you're going to access it is electronically. And I don't feel all that comfortable. I have help around here, but I don't feel all that comfortable that I'm not going to miss something because of my less than stellar understanding of the technology that's likely to be involved here. And so I got to bring people in to be able to help me to make sure I'm not missing that stuff. And so again, you ought to think about, well, can I put this together so that I mark it on the way out is I can do this and I can do that. Jim's guy, I saw he's using a magic pen over here the other day, so when he writes, it somehow keeps track of what we're saying and all the rest of it. I don't know what other technology you're using, but you ought to start to think about using it to an extent where you're acquiring that knowledge over the course of the next year, and you could add that to part of your professional resume as to the skills that you have and how you can enhance that firm's handling of their own client materials. It's an incredibly important skill now. Everything virtually is being done electronically, from your time management software where you're keeping track of your time electronically, to everything that has to do with virtually the practice of law. Every now and then we still have to get up to court, go to court on our feet and try a case. But between the beginning and that stage, much of it is done electronically, obviously. All your filings, for the most part, not for the most part, in federal court are electronic now. So you need to start to get a comfort level if you don't have it, and you just like anything else, you got to force yourself to do it.
I was just curious, what programs specifically that normally use for e-discovery and stuff like that?
There's like 4 major ones, but there's also companies that you can go hire at tens of thousands of dollars to be able to work with you. And there will be times, by the way, where you're going to need to bring someone in from the outside to have a forensic examination of whatever systems they have in place because you think they've either destroyed documents or they're hiding documents. Then you don't have much of a choice. But before you get there, I still need to try and conduct the searches and be able to obtain the media from various formats that then need to be converted. There's a fair amount of technology involved now. I had one just about a year and a half ago with I can say it was Gillette, and sent out this long discovery request, and everything they sent back, including commercials, was contained on a single DVD. So there are times where in a case that size I would have had 50,000 documents. They give me a single DVD with and they did produce everything on one disc, but now it's got to be, and it's not a big deal. That's a pretty straightforward thing to do, to now be able to use it and sort it and be able to see what's there. But that's just sort of the nature of the way that type of practice has changed from a paper-driven process to pretty electronic. And the other part of it is because that's where the information is now. It's not oftentimes sitting in a folder somewhere. Smoking guns are in the emails and the texts and everything else. And I've got to get access to it, and I've got to start to think about, well, how can I get access to it when people say it's no longer there and all the rest. Let's take a look at this first, technology safety systems, because I thought this is part of the thing as you start this is part of the process, part of the problem as you think about the destruction of evidence, and these were the crash test dummies. So we're talking about physical evidence, but think of how easy it is to hit delete when it's not a physical document or thing that you're looking at. And so what does that mean with respect to what steps we can take when we're going to pursue or pursuing litigation, and we have some legitimate concerns that information will be lost along the way. The fact is that information is often lost along the way, sometimes as part of a regular routine business practice, right? I have a filter on my emails that probably scans out 25% of what I get every day. I don't even see it. I often, unless I'm missing, unless someone says, "Oh no, I sent it." Look at, see if it's in there. Do I check it? But that's set. It's usually just crap. But 25% of, virtually 25% of what I get is probably ends up there every day without me even seeing it. What happens if that material was pertinent to litigation or potential litigation? Because that's the other part of this now, right? It's not just when litigation has been filed that you have an obligation to preserve evidence. It's when litigation is likely, you have an obligation to preserve it, and you have an obligation to instruct your client to preserve that evidence. And if not, there are penalties both from the standpoint of the client, obviously, but the attorney as well. Attorney in Connecticut was charged criminally with violations for assisting his client with the destruction of the laptop. And it happens, I think in part it happens because people think it's too easy to get rid of it. But let's take a look at this crash test case, because it starts to have you think about ways of preservation. Although this is a case that I think went kind of haywire with the preservation of evidence. It's an unfair competition case, unfair trade practices, receiving, concealing trade secrets, and what they filed is a motion for an ex parte order of seizure and impoundment of evidence. And listen, the reason we do this, obviously, is we are concerned that if they're given notice and they've already stolen stuff from us, now they're going to hide what they've stolen. And especially if you start to think about unscrupulous parties, it's relatively easy to at least think you've deleted information that was stored electronically. And you may well have deleted it unless I can pay enough money to be able to try and recover it and get access to the original media in some fashion, or what should have been there. So if you look at this case, there was an ex parte request, which means it's without notice to the other side. They got an order for impoundment of the crash test dummies. Counsel then accompanied the marshals. They entered the defendant's business premises. They impounded computer programs, computer printouts, documents bearing the name of the plaintiff, all sorts of things. And what they were saying is this was all critical evidence in the case, and that they are likely to be destroyed or concealed by the defendants if the order wasn't granted. This seems like a pretty tough preemptive strike against the defendant in a what likely is to be a significant piece of litigation. Would you do that tactically? I mean, this whole, the way this, if you read it, the way this played out had to be pretty disruptive. Come in, seize the stuff, marshals are all over the place. Marshals then take the stuff, and we'll talk about the problems with how they stored it then. But geez, this must be almost a preemptive nuclear strike of litigation, right? We go in, seize their computer files, seize what we can, take the software, take the dummies, and then we give it to the plaintiff's counsel to hold. Would you seek such an order even if you thought you only had, it wasn't likely to get it, because in the event you do get it, it has such a devastating effect on the other side?
Well,
an injunction would have been the more appropriate thing to do, to get a court to say,
To say what, though?
don't cease and desist whatever you're doing, and move all of this to a court-appointed third party or neutral site.
So a less restrictive order, just simply telling the defendant, don't destroy it and move it to some type of neutral. See, I don't know how that neutral would work. That's why we have the impoundment. The impoundment, the order should have been that the marshal sees it and the marshal store it, assuming that such an order is necessary. I mean, I wonder to what extent this was done simply to really wreak havoc on the defendant's activities. So think about the way it went down. We're mad, they took our stuff, they took our dummies, they've taken our confidential information, and now they want to compete against us. Well, this is business then. We're going to strike back doubly hard. That's the way we do it. That's the way business is run. If the judge is dumb enough to give me an ex parte order, I'm going to ask for it. Really?
I was going to ask about that too, that how is that not trade infringement on their part? Maybe they put improvements on these things. Now they can see it and they just got it by a court order. Now they're going to take this company's trade secrets.
I think there are situations where companies initiate litigation because there will be business advantages to it. Could be the business advantage simply of disrupting the defendant in almost a chaotic fashion, or it could be Jim's. Let's get in there and take a look and see what we can find. Maybe they're doing things that we should be doing. I mean, this is the problem with these types of orders. It's partly the problem with litigation, though, is that the other side is going to get access to information that at times will be, what businesses would determine confidential. And oftentimes, by the way, businesses will want to call everything confidential. Doesn't make it so.
In this case, wasn't the defendant out at trade shows selling their purported products by using the plaintiff's actual property?
Yeah, well, what about that? I mean, that is, we can talk about how the plaintiff seems to, their actions perhaps could be characterized as over the top, but the defendant is displaying its product using the plaintiff's actual product. There is something not quite kosher about that as well, right? When we say that, well, when we can try and argue that the plaintiff may be making a preemptive nuclear strike, the defendant is doing something improper here. They do appear to have plaintiff's property, and they do appear to be using plaintiff's intellectual property in some way that is inappropriate. Whether at the end of the day it's going to violate the copyright laws and all the rest of it, that's going to be for the court to decide. At a later point, but not now. What about the seizure themselves? The seizure itself, as you saw it here, approximately 1 hour later, after copying machines were set up, the marshals left the premises, leaving the rest of the search party unattended. So now the marshals who were supposed to execute the seizure order, at some point they say, we're done, and they leave the plaintiff in the defendant's place of business. And then the materials were at the plaintiff's local counsel's law firm because the marshals had no space to hold these materials. They all signed confidentiality agreements, if that makes you feel any better. But they're all of this, what I'm sure the defendant would argue are highly confidential pieces of material, the plaintiff now has free access to. It seems like the marshals kind of abandoned their responsibility here too. And then as a result of the conference in chambers, those materials were all transferred to U.S. magistrate judge. Did the plaintiff really have this immediate and irreparable injury that would justify such an extraordinary order without any form of notice to the defendant whatsoever? Because if you think about not just the execution of it, but even not having any ability to be heard prior to the seizure would just seem to mean that what we've got is a situation ripe for potential problems. The bond here was going to be $2,000. The defendant submitted the affidavit that Stephen Fuhr stated the value of the articles seized and copied exceeded $2.2 million. That's what the seizure took from them. They're saying the $2,000 bond was irrelevant. When there's been an injunction, or when an injunction is granted, there should be a bond posted, and the bond that's posted should be in order to compensate the plaintiff. Compensate the party against whom the injunction is granted for any losses they could suffer as a result of that injunction if it's later determined the injunction was improperly granted. Obviously, if the value of the losses here could be $2.2 million, a $2,000 bond isn't going to get close to what we need to do here. You can, as the case talks about, get in order a seizure for the purposes of preserving evidence of the defendant's allegedly wrongful conduct, it says on 649. But there's only going to be certain types of records then that are going to fall within that. There will be situations, as it says on 650, justifying ex parte attachments and seizures. And if you look at numbers 12 and 13 on 650, it's either where notice to the adverse party is impossible or unable to be found, or somehow the defendant's going to render fruitless any further prosecution of the plaintiff's case. If you're going to get a seizure of this sort, you're going to have some evidence that would show that the adverse party would dispose of evidence if given that notice. And then there will be times, but they're going to be rare, where that then, if you can show that if you gave them notice that destroyed the evidence, that then you could justify the ex parte order. But obviously, since an ex parte order does away with the defendant's right of due process, you're going to have to show that there's no less drastic means for protecting the plaintiff's interests here. That just isn't the case here with this seizure. I do like Matt's point. I think Matt's point is probably why, at least in part, why the plaintiff went in for this order, is that at least some of their activities were relatively brazen. And I think the plaintiffs were concerned both about the economic threat of this new competitor and the lengths they would go to be able to compete. Even still, it just, as the court said at the end of the day, it doesn't justify such an extraordinary order or the execution of it here. It is, in fact, an abuse of discretion. I would still use this case as a case that illustrates that you can get a pre-trial, virtually pre-case order for the seizure of evidence if you can show that there's some likelihood that the defendant will destroy it if given notice in advance. And I think there will be cases where you have such evidence. There are times where parties will say, I'll burn this house down before I sell it to you or turn it over, or words to that effect. There's other types of things from time to time where that because of the statements and evidence, the information they've given you, that this information will never be available at a later point. I've had defendants in more than a few cases destroy evidence and alter evidence during the course of litigation, and unfortunately, it's harder then to go back and prove it. But without knowing that would be likely to do that in advance, it's hard to go in and get an order seizing that evidence at the outset. The fact is that we do have sanctions for what we call spoliation of evidence, even unintentional destruction of evidence in Massachusetts. Even the unintentional destruction, the negligent loss of evidence, carries with it the penalty that the court should instruct the jury that the party who lost the evidence or destroyed the evidence did so because it was likely harmful to them. And the jury then can infer that the evidence would have been favorable to your client. And that's for negligent or intentional destruction. And I think it carries over with it, as you think, to situations with respect to electronic discovery. There's just information so easily lost or destroyed that the issue comes on the back end. How do we restore the information to the hard drive or wherever it was held? How do we get those text messages that were deleted or the emails? And that becomes an expense on the back end because sometimes we just have a hunch and we're fishing, and we may not get an order from the court to allow us to go in and inspect unless we have more than just a hunch. You're going to have to show something that would justify that level of intrusion. It doesn't take a lot, and because there is an obligation on your part to preserve that evidence, but the fact is it's not always preserved as it should be. Let's talk about Campbell Soup versus Giles as we start to think about the practical effect of how injunctions work and how they are issued in the process for the issuing of those injunctions. We have a couple of rules that we're supposed to look at in Section 5.2. Rule 52 we talked about last week. Rule 52 is a requirement that in jury-waived trials, so in any type of pure equitable action, the judge must make findings of fact under Rule 52. When we looked at the Pier 4 case, we talked about that. Rule 52 requires the court to make findings of fact and conclusions of law. Good lawyers provide the court with proposed findings of fact and conclusions of law. And then lastly, Rule 58 is the entry of judgment, and that's just a very basic rule that says that a judgment by the court has to be entered separately, both in the docket and on a separate piece of paper. And so even if there's a court order, an injunction of some sort, that becomes a judgment of the court and it has to be separately filed within the papers of the case so that you can see, in fact, what the specific order or judgment of the court is. This does, believe it or not, sometimes become an issue because of a clerical error or whatever. There is no formal document that should, as the rule requires, be evidence of that judgment. And when it is, it can pose problems with the enforcement of that judgment, either by way of contempt or otherwise. So Rule 58 on its face looks relatively technical, but sometimes in practice it does pose a problem. Campbell Soup versus Giles, let's just actually look at the practice as related to the injunctions. This is a First Circuit Court of Appeals case, so this means it comes out of our circuit. And it was before Judge Gorton. And it says Judge Gorton denied the request for preliminary injunctive relief, manufacturer appeals. It went on to appeal. And it said, and then the question is, how does this process work? And we've got a trade secret case, or at least an argument about trade secrets. So let's take a quick look at it. And again, as you start to think about it, or as you should start to think about it, businesses are always going to want to try and protect all of their information. And oftentimes they'll call virtually everything a trade secret or confidential information. They may want you to sign agreements that you won't disclose the material to other people, or the press or anyone else. But the fact is that we have a public court process. And the fact is not all information, whether the businesses like it or not, is going to rise to the level of receiving that type of protection from public inspection. And so I always take quite skeptically the defendant's claims that it's all trade secret and confidential information, because if they haven't protected it up to now in certain fashion, just because they don't like how it plays out in court at this point doesn't mean they get to hide what took place from the public inspection. That's what the First Amendment is about. So let's think about it with somewhat of a skeptical eye. All the claims by businesses of trade secret, confidential, and proprietary information, because just not necessarily the way it's going to be. So they sought a preliminary injunction barring Giles from assuming his new position, at least through the end of the fiscal year, or otherwise making use of Campbell's trade secrets. District Court denies the PI. Campbell had satisfied none of the five-part test. Campbell now appeals, complaining that the court erred to conduct and failed to provide them with an evidentiary hearing. So let's take a look at the facts. November 1st, Giles left Campbell's employ to undertake similar duties at PET, which is Progresso, and one of Campbell's chief competitors. Campbell files a diversity action, you know what that is, against Giles, claiming breach of contract, misappropriation of trade secrets, unfair and deceptive trade practices. He responds by advancing a series of counterclaims, including one for intentional interference with contractual relationships. The trade secret information that Campbell says Giles has falls into two categories. Marketing information for 95 fiscal year. The existence and nature of a secret project involving a new product line scheduled to be launched in 95. And then some marketing information, pricing strategies, and some other stuff. Campbell says only 30 to 40 of its employees out of a total workforce of 40,000 were said to even know of the project's existence. Giles is one of the few who had been informed of the details. Any premature disclosure of the products would allow his new employer, as they saw it, to take advantage of what they felt they spent too much money and too much time on in developing, that someone else should now be able to take advantage of it. Take a look at the footnote 2. It says, upon beginning work for Campbell back in 1981, Giles had signed a patent trade secret agreement obliging him not to use, divulge, or publish any of the company's trade secrets without consent, either during such employment or thereafter. No non-competition agreement was ever signed. Campbell's breach of contract claim alleged a violation of the trade secret agreement. So it's the trade secret agreement they're arguing, but he doesn't have a non-compete. Again, these non-compete agreements and their attempted enforcement is where I see a lot of these companies have using them potentially for their own commercial purposes. And I do think that especially someone like Giles here is at a significant disadvantage trying to litigate a suit against Campbell Soup Company when all he wants to do is just try to work to pay his mortgage and all the rest of it. Giles says, this is no big deal. Most of this information is out there. I never signed a non-compete. Shouldn't he get to go work for the other company? Because it seems like you're going to have an awful harsh result if he can't work, what does it say, at least through peak soup season? Did you know there was a soup season? Well, it says here it ends in March or April, which seems logical, I guess, if you think about it, right?
There was soup in the summer.
Huh?
There was soup in the summer.
Well, there's a peak. So, but if this guy can't work, and this is what happens in a lot of these, if you can't work for 6 months, you're bankrupt, aren't you? You know. And in this case, he doesn't even have a non-compete. He does have an agreement, a patent trade secret agreement, not to use or divulge any of the company's trade secrets without their consent. But what trade secrets is Campbell able to show that are involved here? If you look at the bottom of 469, when they evaluated against the 4-part test, I think Campbell's has a tough shot here. They don't have a non-compete. What's the trade secret?
They argue it was their marketing strategy and something about secret projects.
But what makes it a secret project? Just simply because it's new?
It's a new soup.
So it's a new soup. Well, I guess, but most of the marketing information is no longer confidential in light of its public disclosures. He's privy to some marketing information, but he doesn't have much about the project. At the end of the day, Campbell should get money, if anything. They shouldn't be able to prohibit him from working, is what he says. Look at under Roman numeral 2. On the preliminary injunction, the movement's likelihood of success in the merits, potential for irreparable harm, balance of the relevant harm, equities they call it here, and the effect on the public interest. The only one they don't have is the no adequate remedy in law that we talk about, which means money damages won't make the plaintiff whole, but they did that in the paragraph above. That's what they're trying to argue here, is that, well, if we assess this against these facts against the standard on a preliminary injunction, don't the equities really tip in favor of Giles here? He doesn't have a non-compete. He does have this trade secret information agreement, but what evidence does Campbell's have that shows that he's violating that agreement? Campbell's wants to focus a little on the procedure here too, so I want you to focus on the procedure. Campbell's comes in. They're the ones that file the complaint. They're the ones that file the request for preliminary injunction. The defendant responds in some fashion. It may be, by preliminary injunction, he may have an answer, may not. Depends on, could still be 10, 15, 20 days into the case. It's not long. But there may be an answer, there may not be an answer. At this point, they've got a request for preliminary injunction out. The question is, okay, so what is the next step in the process here as to how that hearing on the preliminary injunction would take place? Campbell says they're entitled to an evidentiary hearing. What does that mean?
They want to go to court and present whatever they had to say. Okay, for example, I can see their arguments with the marketing strategy.
No, but tell me what an evidentiary hearing would be. What do you think?
Present evidence to the judge that says this is our marketing strategy and this is what.
Evidence how? How would you present evidence in that fashion?
Discovery.
Well, no, it's not going to be discovery. This is a hearing. So tell me how it works.
So parties witnesses are sworn in.
Right.
And they're direct and prosecuted.
Yeah, right. Just as we would think of, and as we think about a hearing, what they're saying is we want an evidentiary hearing. We want witnesses sworn. We want them examined. We want them available for cross-examination, and we want to have the ability then to physically offer evidence for the court to assess in determining whether the injunction is appropriate or not. They want a full-bore hearing early on in the process. And think about it strategically, by the way. Why not? Why, right? A, why not insist on getting it because I didn't get it? So maybe that made it an error. B, why wouldn't I take my crack at early discovery? Why wouldn't I take my crack at being able to examine witnesses under oath? All of this preliminary injunction hearing process is likely within the first 60 days of the case. If I'm the plaintiff, I'm controlling those first 60 days of the case. I've had this case for longer to be able to be ready. I've filed my complaint. I've filed my motion. It's been supported by way of affidavits. Frankly, if I'm the defendant, I might want an evidentiary hearing. I don't want you to just do it based on the memo and the affidavits and the memorandum that they've submitted that say they get it. Put those witnesses who signed the affidavits on the stand. Let's have them sworn in, and let's see if they stand by what their lawyers wrote in those affidavits. Because that's who writes the affidavits, right? It's us. And it's very easy to tell someone, give it to them and say, sign it. Let's see if they'll stand behind it when they're under oath on cross-examination. The likelihood is there's going to be wiggle room here. If I were Giles, it wouldn't bother me necessarily that they want an evidentiary hearing. Let's find out whoever's saying this is trade secret information and see exactly what they're going to testify to was trade secret and how that was protected within the company as trade secret information. The fact is, it doesn't hurt necessarily, it depends on your position, it doesn't hurt to go forward with an evidentiary hearing. You guys, in seeking a preliminary injunction, should worry that that may well take place. And frankly, if the court is not inclined to do so, I'm going to insist that I'm entitled to get it because it gives me more opportunity to defeat the injunction. If I think I'm going to win, maybe I won't push it as hard. But this whole notion about an evidentiary hearing oftentimes means that I'm going to get access to witnesses at a much sooner standpoint than I might otherwise, and it also gives me a chance to disrupt the granting of the injunction or allows me to help oppose the granting of the injunction. Campbell's just saying, well, what the hell? I didn't get any real evidentiary hearing. We submitted the papers, the court denied it, off we went. So the question I have for you is, well, under what circumstances does Campbell Soup say that you actually do get an evidentiary hearing? Because that's what the language we're going to need to know if you intend to insist on an evidentiary hearing, because it talks about the First Circuit here in Arabic 2 and 3. It says some other courts have adopted categorical rules in this regard. We have indicated the balancing between speed and practicality versus accuracy and fairness should be entrusted to the district court's discretion. What the hell's that mean?
Fishing.
Huh?
Campbell's kind of fishing. They don't really have anything. Their claim's not really meritorious. They have nothing really, on its face.
So as a general matter, it would be okay for the court to either grant or deny injunctive relief simply upon hearing the parties on the papers submitted, right? So under what circumstances is it inappropriate for the court to either grant or deny injunctive relief simply upon the papers submitted?
Well, they have to abuse their discretion.
Well, what would constitute abuse of discretion? Charlie?
I'm trying to find the wording, but I think it was like when the facts are in sharp contrast.
Oh, you're
It
close.
said something like that. I'm trying to find it.
Anyone else?
I believe it's sharp dispute.
That's what it says, right? It says, when the parties' competing versions of the pertinent factual events are in sharp dispute, such that the propriety of injunctive relief hinges on determinations of credibility, the inappropriateness of proceeding on affidavits alone attains its maximum. Okay, what that means, and this is always the case in these situations, if you can say it's a credibility issue, then you shouldn't be resolving matters on paper. You should be looking those witnesses in the eye. If there is a sharp dispute with respect to the facts at hand, then again, the court shouldn't rest on papers. They should bring witnesses in, swear them in, and have them examined. So if you're going to insist on your, quote, right to an evidentiary hearing, which is a pretty limited right, as you can see, then you're going to have to say that the pertinent factual disputes events are in sharp dispute, and that the granting or denial of injunctive relief hinges on the credibility of the witnesses, and therefore it's imperative that the court actually see those witnesses and determine their credibility in a face-to-face fashion. Because beyond that, if you look at number 4 here, both Campbell and Giles get to present whatever information they want by way of paper. They file their affidavits. Campbell files a motion as well as a memo that would support it, and Giles has the ability to file counter affidavits and memos that oppose it. The fact is, you can provide anything you want to the court in that process for them to review. And unless you're going to be able to show there's a sharp factual dispute, you're not likely to be able to insist that you have a right to an evidentiary hearing. It says over the course of 18 days, Campbell submitted an abundance of materials, and it tells us what all the stuff they submitted. And then the defendant had the opportunity to present information as well. That just is Campbell's doesn't have a right under these circumstances to an evidentiary hearing because there really is no sharp factual dispute. Giles is a mid-level sales position here, it says. He's not the head of the company or really someone who has control over what was at stake here. If he was that important, and this is what I would argue in opposing it as well, if he was that important, he should have had a non-compete. If you want to, in essence, say his agreement is akin to a non-compete, then pay him in accordance with what a non-compete would require, and then have him sign a non-compete. Here, what they were doing is trying to take a trade secret agreement and turn it into a non-compete, and as the court, I think, correctly found, the harm to Giles would be significantly more than the harm to Campbell. Lastly, is this page 472, and they refer to the Ayoud case, which we're going to read soon. it says, even where Rule 65 fact-finding is desirable, it is designed to be tentative in nature. The web of conclusions upon which a preliminary injunction rests are statements of probable outcomes, nothing more. What that means is that even if the preliminary injunction is granted or denied, that doesn't mean it's a final determination on those factual issues that will be resolved at trial. What it means is that, at least at this point in time, you either have or haven't shown that you have a legal need that would satisfy the legal standards to get injunctive relief. But the fact is that you could win on a preliminary injunction and lose down the road, or you could lose on a preliminary injunction and win down the road, because it's not a final determination. It's not res judicata for the purposes of the facts. With that said, as a practical matter, if I win the preliminary injunction and it's an order that I needed to get, the likelihood is that the pressure is now on the other side to perhaps either settle or resolve the case favorably to me, because that injunction, the longer it's kept in effect, at least some of the argument the defendant would raise is that it's causing harm to them. And so winning the preliminary injunction or getting it denied early on is a significant advantage, even though it's only a preliminary finding of facts that isn't dispositive on the case. Lastly, I just want to again point out this whole idea that Campbell's asked that all of the ballot papers be impounded. And again, when you're working with some of these companies, they always want all of the information impounded and preserved. I don't think it's as much worried about trade secret or confidential information as worried about the press getting access to some of what they may be doing here and feeling it's inappropriate and not necessarily flattering. In some cases, there actually is legitimate trade secret information, but it's oftentimes an overused cry. Republic of Philippines versus New York. They needed a receiver to manage and control the buildings. And again, we had a request for preliminary injunction here. And this is a complicated set of problems in New York. Bunch of equitable claims here. We have someone who seeks to intervene as of right as well in the proceedings. There were oppositions to the motions for preliminary injunction, and then at some point there is an order, and by way of the order, the court determined that there was a need for the receiver to manage this building, and that's what a receiver does. A receiver is also an equitable remedy that the court can appoint, either after judgment or before, and the receiver in essence will take control over the defendant and take whatever steps are necessary in this case, to manage the property while the case is pending. In some cases, post-judgment to satisfy the orders of the court post that judgment. And so they originally call him a receiver, and then they decide to call him a special property advisor because they think that's a little less restrictive. If you look at the top of page 36, it says, while the appointment of a receiver is an extraordinary remedy, which should be employed with utmost caution and granted only in cases of clear necessity to protect plaintiff's interest in the property, the special property advisor, which I'm not sure you're going to find another case anywhere before this that ever uses that term, is far less intrusive. You know, the fact is here that, as it says, equitable remedies are supposed to be flexible. Equitable remedies are supposed to allow the court to use its broad discretion to fashion appropriate relief. And the fact is that this case could take so long to wind its way through that that we might find that by the time it does wind its way through, that if these buildings aren't preserved, there'd be nothing left to be fighting about with respect to the court's final judgment. Again, this case, though, is here as much for this evidentiary hearing notion. Appellants claim that they should have been, in Arabic 3, claim that there should have been an evidentiary hearing before the order was issued. And this case gives us a pretty basic principle. If you want an evidentiary hearing, you got to ask for it. And if you don't ask for it, don't argue on appeal that you should have had it. And so again, because this was from New York now, what their determination was that they've held on a motion for a PI where essential facts are in dispute. There must be a hearing and appropriate findings must be made. Findings under Rule 52 that we talked about, because it's going to be a judgment of the court. And then it goes on to say, though, in that paragraph, it is not a rigid requirement that oral testimony be taken on a motion for a preliminary injunction. But again, we've got very similar language to what we saw in the last case, is that if they're in sharp dispute, here it says if essential facts are in dispute. The fact is that would again give us this argument about why you should be getting an evidentiary hearing. But if you're not requesting an evidentiary hearing, don't come back later on and say, oh, we never got an evidentiary hearing. If you want it, you have to request it, and if you don't request it, the court is under no obligation to give it to you. You want to start to think about using the language about the requirements that the essential facts are in dispute, the credibility of the witnesses is an issue, and that the sharp dispute then means that absent an evidentiary hearing, the court is not likely to get to a wise resolution of those factual contentions. Lastly, they make mention of Rule 52, which is this findings of fact here. And again, it talks to you about Rule 52 requires a district court to set the findings of fact and conclusions of law. It's the court's reasoning as to why the injunction should issue. It requires the court to assess the evidence and think about what arguments are in favor or opposed to granting the injunction. It also allows, as it says in the bottom of 37, allows the federal court to review that process to see if it then justifies the issuance of the injunction. And so when we're talking about granting injunctions, which by a court, by a judge, then Rule 52 has to be followed so that the court can see what the argument is that would grant, that would justify the injunctive relief. And when we think about injunctive relief, we have to think about it as an extraordinary remedy. Last case for tonight is your Great American Chocolate Chip Cookie Company case. And so it's another one of these franchisee problems. And what happens here is that there's a magistrate involved in part of the process. It says the magistrate judge's opinion. Magistrate judges work with federal court judges. And in many cases, you can ask for a referral to the magistrate judge usually for discovery matters, or even if you wanted to try the case before the magistrate, you can do that. But I never want to. It's faster. You would get the trial before a magistrate faster than you would with the federal judge. But then the federal judge still has to ultimately adopt the trial, adopt the findings of the magistrate judge. It's just not a process that I've favored. I have used magistrate judges for some discovery disputes. I've used them for mediation at times in federal court. It's not that I would prefer my case be simply transferred to the magistrate judge. As a general matter, I would want the more experienced judge handling the case, and that would mean not the magistrate judge as a general matter. but obviously you should look and see which magistrate judge works with the judge your federal case has been assigned to, and maybe it makes more sense for you to think about that. I just don't favor it, and it may not be as much reasoned as gut, but it is what it is. They want an injunction here stopping this removal of the franchise. What's the problem here with the way in which the cookie company is running its franchise? Because it would seem like the Siegels simply want a motion for injunction. The cookie company wants an injunction against the Siegels to stop violating the trademarks. One of the arguments I saw here is that they've borrowed money to be able to invest in the cookie company. They have another store that seems to be going just fine. And not only will this potentially bankrupt them, but Mrs. Siegel's father, all their houses are pledged, his retirement's pledged. If they don't get this injunction, they're out of business. And not just out of business, maybe living in a cardboard box. Shouldn't the Siegels get their injunction? I mean, on a straight harm, isn't the harm to the Siegels much greater than the cookie company, or no?
Irreparable harm.
Is it? Does the cookie company have any irreparable harm?
Their brand could be damaged. I mean, there are all these notes about oozing cheesecake and undercooked cookies and things like that.
Oozing cheesecake, undercooked cookies, cleanliness of the store.
Yeah, so their brand is suffering damage.
What do you think? What about that? They wanted a preliminary injunction. They say, listen, we've got harm here. The way in which this franchise is running is potentially going to really injure our brand. Isn't it?
It's not irreparable.
It's not irreparable? So I go into Great American Cookie Company somewhere and I get rat hair in my cookie. I think I'm going to go somewhere, another Great American Cookie Company somewhere else.
Jack in the Box never really recovered its image after that foodborne illness.
That's right? I don't even, are they still even in business?
They are.
Hawaii.
Everyone's
In
still
Hawaii? That's it?
Nice.
How would you know that? But what about that? I mean, Matt's point is that an incident could be significant. In and of itself enough. I mean, because I'll tell you, when I first read it, you say, was it oozing cheesecake or running cheesecake? That really doesn't sound like the bubonic plague is in the store. It sounds like you've got a bunch of kids behind the counter who aren't doing necessarily what they should do. Well, that's the world, isn't it? I mean...
Well, if I go to a Dunkin' Donuts and I don't get my coffee the way I want, which is really simple because it's just black, I don't go there. I go to another one.
But, you know, you go to another Dunkin's, don't you? So you didn't hurt the brand, you just hurt the store.
Well, sometimes I go to Heavenly.
I like Heavenly.
I don't like them better.
Huh?
I like them better a little bit.
Me too.
I hate Dunkin' Donuts now.
No, but you can see how you can go to, like, say you go to McDonald's and it's dirty in there. It's not, you know, now they're not keeping up with all the things that you're paying for to have a franchise. I mean, you could, you know, I mean, depending on the size, but it's still something that you would want to stop immediately. I mean, you know, you're represented by people that aren't representing you, I guess.
Well, let me just say, go ahead.
Talk about Dunkin' Donuts. I go back and I return it. Maybe because I work there. I do. I work there. I work the hardest shift ever from 2:30 a.m. to 10 a.m.
So no injunction.
No, the kids don't do their work. There's times for coffee to be run. There's every 20 and 30 minutes you have to.
You know, but because I don't like sugar in my coffee, and sometimes, you know, you're...
Well, what
so
if you're diabetic and they put sugar in your coffee?
Okay, but I'm not. But I hate the taste of sugar. And so now I'm 3 minutes away. I taste it. I'm not going back. If I go back, I'm not going to be nice. No.
Cream.
Well, right.
Yeah, you're gonna.
That ruins your day.
It's gotta be real bad to have to go back after you already drove out of the drive-thru, you know what I mean?
I'm probably not gonna drink it, but what am I gonna go back and fight with the kid who couldn't figure out what a black coffee is supposed
The
to?
next one down the road, I do it all the time.
You drive to the next one.
The next one down the road, wherever I'm going. Oh, they screwed up my coffee in the last one.
Yeah.
Oh, you did? You
Yeah.
did? And they'll fix it for you?
Yeah.
I didn't know that.
Yeah, I'm not going back. Well, but see, that's better for the, okay, but anyway, that's better for the brand, frankly, that they would fix it at another store. I never would have thought of that. That's actually.
They do anything like that these days at like a...
Well, because the coffee probably cost them 10 cents, you just paid $3 for anyway.
Don't you think most people know that they're franchises, that they're not all owned by the same? Well, I mean, the ones around here are probably all owned by the same guy, but...
Well, but I think so. But let me ask you, don't you, Matt's point, don't you, I mean, it wasn't just the runny cheesecake, right? They were cheating them on the supplies, they were cheating them on the accounting. The store sounded kind of dirty, right? And food and dirt just don't really tend to go well. Can't they make a legitimate claim that the running, that they're in breach of the contract, and B, running of the store potentially does cause us serious harm and harm to our business interests? I mean, that's their case here, is that A, we assess the 4 factors. No adequate remedy of law, money damages will make us whole, you're harming our intellectual property. Likelihood of success. They're in breach of the contract, aren't they? I think the Seagulls are trying to say, well, they're not that big a deal. Well, you cheated me on the money. You cheated me on product that you're only supposed to buy from me. You're running a filthy store with gum under the counters and stuff too, right? And the product that you're delivering isn't anywhere near our quality standards. I mean, and there was more. I think those are there's more than that, is my recollection. And so balance of harms, the cookie company says they have a lot, but the Seagulls, what do you think about that Seagulls argument saying, listen, we're going to lose everything. We're going to lose our houses. We're going to lose the store we are running well, and Dad is going to be out in the street.
Should have done it right. Somebody opens up a gentleman's club across the street called MSL, you know what I mean, and they spend all the money to put it in. Hey, bad for them, you know what I mean? What the hell?
I don't even know how to respond to that one.
All right, I mean, you know. Well, you'd have a problem with that, wouldn't you?
Yeah, but I really don't understand how that's relevant to this discussion.
Well, I'm just saying, I mean, they're using their name, you know what I mean? And
Okay, fair enough. They're professionally, they're damaging their name professionally within their various breaches of the contract, right?
Right.
But wait a minute, though. Let me ask you. Seagulls have some harm, or is that harm tough luck? That's a consequence of your running a business poorly, not taking care of your dad properly or your dad's money, because all you had to do was not cheat us, not run such a dirty, filthy store. Cook the stuff right, and this wouldn't be an issue. Because he's going to lose his entire retirement. They're going to lose their houses. Doesn't bother us. They're in breach of the contract. Out they go.
Well, report them to Elder Services and let them take care of it.
Yeah, that should work out well. Right? That's your plan?
We should, if they're going to be that slothful in running their business, oh wow.
That's what I'm actually wondering that a little bit. That's not on me, that's on them. Because I'm sort of thinking, if I represent the franchisor, as a little part of me feels bad that the old man's going to lose everything. No?
I don't think
That's why.
You know?
I think it's foreseeable if he's putting that down for leverage, that he has to assume that at some point in time he could lose it.
Where'd you find Mary Lou's?
Social.
I thought you were just south of Boston.
I grew up in
Oh, okay.
I think their harm outweighs the harm of this franchise. It doesn't matter.
You think who's harmed? The Seagulls?
Yes.
Because the financial losses.
Yeah.
They brought it upon themselves.
Yeah, I don't think they would weigh that in.
You know what? I hear you. They brought it upon themselves. They should have run a better store. It's not my fault. The father didn't. The father should have known all this. Listen. You know, people come in, they've co-signed stuff, and you say, "What were you thinking?" Because now they're holding the bag, and you feel bad for them. But so is that it though? The lawyer. Listen, it's not on me. It's on them. Matt, you were going to say something.
Oh, I was just going to say that looking at the terms of the contract that they put down here, it's actually more fair than some of the other ones. They can breach 3 times or 2 times, and then only after the 3rd one does the company have the right to terminate their franchise.
Yeah, I don't disagree with you on this. I mean, I think my guess is that we can read it and say, oh, how harsh this is. It does seem like
They gave 2 opportunities.
and they didn't even say tend to the store back and keep your other store and off we'll go, right? I mean, they unlike some of the other ones we've seen, they're not the black hats here. They tried. The results could be quite harsh, but the results are in some cases, in some ways, pretty expected. And again, as a lawyer, I'm really not responsible for everyone else in the world's bad choices.
I wouldn't even weigh that in. Like, it just seems like...
You wouldn't weigh it in? Seriously, you got a 70-year-old man crying in the courtroom when you're seeking the injunction?
Well, no.
Are you serious? You don't think...
Well, yeah, on a personal level, but I mean, it's like, all right, if they open up...
Maybe you can cut my lawn.
You're cold.
if you opened up a substandard law school across the street called MSL, for example, just because you spent all the money, you didn't realize that, I didn't realize it would, be a conflict or something. I mean, you can't, you feel bad, but hey, you knew the rules, you signed the contract, you have to either keep that or that's too bad for you. Kind of,
Sometimes it's not that easy.
I don't think that's even the same thing.
Well, so go ahead. Just tell me though. You said it's not that easy. So you're still going to do it? You have the right to injunction. I actually don't think it's that close, right? I guess that's what makes me feel better about this. I could represent the franchisor here without much worry because they really went. I sort of agree with Matt. I think they went out of their way to try and work through this. They gave them opportunities. You had a chance to fix it. I'm not the one that pledged your father's retirement here. That's on you. And then for you not to recognize it and take care of it, when you could have fixed it, that's not on me either. At some point, my client's entitled to what they're entitled to under the law as well. I feel bad. I think I'm going to feel bad if I see him. I'm going to feel bad if he's not in the courtroom. I'm going to feel terrible if he's sitting there crying while I'm getting that injunction. But I'm going to get the I'm going to seek the injunction, right?
It's not your responsibility to bear his consequences.
No, right? That's it. That's responsibility lies with his.
After any other franchisee would have done this. They just sort of like, it's done, we're going to seek the injunction, we're going, we're taking what's ours. And they actually tried to cooperate with them.
Listen, I see, that's the thing. That's, to me, what makes this relatively as harsh as the consequences are likely to fall on the defendants. To me, that's what makes this an easy one to work with, because your client has tried to go above and beyond what they're required to do. And the fact is, at the end of the day, it's going to be a harsh result, or it should be a harsh result. But the fact is that these are the defendant's own choices. And by the way, you get some defendants that will make bad choices, not just pre-litigation, but throughout. And at some point, you can see where it ends. And again, you should have settled. It's a bunch of things you could have done before we got to this point. Don't wait till then and then expect me to feel bad about what the results are of the consequences of the choices you made. Right? I mean, that's and that happens often, and then people expect sympathy, and it's hard. You can't justify it at that point. Your client, from a business standpoint, isn't going to justify it, because at the end of the day, it's a business deal. and frankly, to some extent, it's a business deal for you, representing the interests of that client. The Seagulls are arguing that the company behaved opportunistically. The court is just not buying any of that. At the end of the day, this court feels that the cookie company is entitled to an injunction it sought based on the balance, based on the four factors when it looks at with respect to contract law. As it says here under 19 and 21, and I think this is really the gist of what we were just saying. It says contract law does not require parties to behave altruistically toward each other. It does not proceed on the philosophy that I am my brother's keeper. We're not each other's fiduciaries. The results here are going to be harsh, but the results here are because of the defendant's many breaches of the agreement and just bad business judgment as they went about this case, thinking that their harms there, and they were it's a very sympathetic case, but that those harms would outweigh the plaintiff's case, and they just do not. So on Thursday, we'll be on Section 6.
I have a question.
Yeah.
At the start of the semester, you said you would have the option to do the online quiz for midterm.
The online questions, or we can have a midterm in class.
Okay. So
the online questions are posted each week. You would have the opportunity to do those during spring break, and they're due the Monday following spring break, which I think is St. Patrick's Day, the 17th.
They're posted on Twine?
No, they're posted right on the website for this class, which is on mslaw.edu. As a general matter, most people, what it's been over the last few years is no one's wanted a separate exam, because the questions then, if you do the questions, you then have them prepared and have them for review for the final as well. I'll do whatever your pleasure is, but I'm going to need an answer, because
Class decision on the individual?
No, individual decision. If someone says, no, I want to take the exam, then I'll have an exam ready. So, yeah, it doesn't need to be a group decision. Yeah?
Is it up to Section 7 or up to the end of the...
Huh, you're right. It'd only be Section 7, because Section 8 we don't do till we come back. So it'll be through Section 7 would be the questions that are posted for those weeks.
How does the curve work if I'm the only one to take the exam? Does that mean I have to get an A?
No, it means you have to get the F. If it's you. No, there's no curve on that. So you'll get what you deserve, Mark.
Also something we have to email to you. Do we have to email you any?
Say again?
Do we have to email you any thoughts or?
Yeah, you're supposed to send me the 3 things you think are important to whatever it is you're ultimately going to practice in, or what you're presently doing, what you think are fundamental to that.
Thank you.
So Thursday, I just want to we'll get a show of hands of how many want a separate exam and how many are going to do the online questions. You need to, there can't be that many if it's only 7 sections. You need to send me the answer to 103 questions, or bring it in to me, and then at some point I'll give you, for one of the weeks, or for the week, that might be that week too, because I'm away down in Boston the end of that week. I'll give you a draft of a complaint that you'll have to fill out. You'll have to draft a complaint. Yours are on the floor upstairs. Taking good care of them. I'll get them, I promise.